Donald Trump judge Aileen rejected parts of the special master's case management plan, causing a lot of eyebrows out there in the legal world to go, what? You're kidding me. Many were thinking that Judge Cannon was just going to rubber stamp anything that came out of Special Master Raymond Dearie's office because it's a special master and he's got all this experience and he's somebody who's been on the bench a lot longer than Aileen Cannon was. And so we're seeing sort of this seniority battle play out. And we covered on this channel previously the actual case management plan that was proffered forward by Special Master Dearie. And remember, Dearie said, hey, government, you're going to go and fill out this spreadsheet. You're going to make it look all good. All the stuff that you took out of Trump's residence, go put it in a chart and label it for us. And when you're done with that, send it over to Trump's team. And Trump, this is your last opportunity. You got to go through this list and you got to vet it and corroborate it and make sure it's good and all these things. And Trump is saying, hold on a minute. I don't even know what they took. And I've got the presumption of innocence and I've got all of these protections and executive privilege and I've got Presidential Records Act and I have declassified these things anyways. And so why do I have to present this evidence when they haven't made their showing first? And there's been this back and forth and around we go. And so yesterday we had talked about the order that was proposed by the special master that went into the court. And Trump and his team are now responding to it. They are objecting to it. This is the letter to Judge Dearie from Donald Trump's defense team. You can see it's drafted September 28th. It's 5 pages long. And it's regarding the special master and the government's requests for some modifications to the case management plan and to process all of the materials that were seized. Trump's defense team says, Dear Judge, while Trump does not object to the government's request for additional time, its recent submission represents an inefficient multi-step process that's ultimately going to lead to the adoption of a more realistic schedule like the one that we suggested from the start. And remember that this was a complicated process. There was all these sort of checks and balances and put the spreadsheet here and fill the spreadsheet out here and then transfer it over to these people and to those people and so on. And it takes time for all of this stuff to be done. And so as we've talked about on this channel, prosecutors are very, they're kind of dorks out there, if I can be real blunt about it. And shout out to all the prosecutors out there. You know how much I love you. But, you're come on, let's be real about it. And defense attorneys are much like this. They just say, hey, these weirdos, they're doing all of this, this mechanical maneuvering. And they say, we had already told you it's going to take a long time. And we said that from the very beginning. They say at the status conference before the special master, the plaintiff suggested that the dates put forth in the draft case management plan were unlikely to prove feasible in terms of both the likely start of the document flow and the man hours necessary to review more than 11,000 pages or documents. Now, they're saying that this is going to take a lot of work and we're trying to figure out the best, most efficient process. Trump's defense says, indeed, Trump suggested that a rough rule of thumb in document reviews is 50 pages per hour. We've done this before, they're saying, and this is the standard. Building into his calculations the review and the categorization of the filter team documents, the successful recruitment, retention, and the startup operation of a data vendor. Remember, because all of these thousands of pages of documents, they're not, Trump's lawyers are not going through this, and the prosecutors are not going through this. There are companies that do this, and they're going to go label everything and organize it all for them. And Trump's people are saying, we got to get them going and get them up to speed because this is going to be a big problem. And they say, you also got to get them going, start them up, the requisite review, the categorization of the documents. All of this suggests a mid-October date as completion. And they say that government, those prosecutors, Judge, they assured Your Honor that a minimal adjustment of quote, only a couple days was all that was needed. But otherwise, the plan was perfectly acceptable. Right. And so he's sort of blasting them right here. He's saying, Judge, they want additional time, but they came in and told you they didn't need additional time, that everything is basically good. Right. That everything is if we have to modify anything, it's only going to be around the margins. Now, Trump's defense, they say, Judge, now, for the second time since its blithe dismissal of practical experience, since they just shoved us in the garbage, they said the government comes to the court to readjust deadlines. Prosecutors are back. Judge, they came the first time, they're back again. And again, the government requests the plaintiffs more realistic deadlines as unnecessary. So they're asking again for an extension, but they don't want to go as far out as Trump. To be clear, they say, we think the prosecutor working with Trump's lawyers to navigate this process and beginning all of this is acting expeditiously and in good faith. So they say, look, we don't think the government is trying to delay this, or to intentionally stonewall this or drag their feet. We think that they are moving quickly. We think that they are acting in good faith. However, the overall position of the government continues to be overly optimistic and aggressive in terms of the timing, which is why Trump respectfully renews his position that the mid-October deadline is a realistic final production deadline. It is actually, we can push it out, that far enough, Judge. You can do that. Stop making us come back in and ask for these little minor marginal extensions. They came back the first time and said they needed more time. You gave it to them. They came back the second time and said they needed more time. You gave it to them. So why don't you just do what we said in the first place and bump it all the way out till middle of October? The problem is compounded by the fact that when Trump's lawyers referred to either 11,000 pages or even 11,000 documents, now do you see this distinction here? 11,000 pages or 11,000 documents. They're not the same thing. They kind of look like they might be, but they're not. And they say when Trump brought this up during the status conference at the last setting, we're still awaiting the transcript, they say, by the way, in quotations, in parentheses. They say, hey, pages or documents. We had an argument about this at the last setting, but we're waiting for the transcripts. We still haven't gotten those yet. The government chose not to inject with an accurate number, interject. So is it 11,000 documents? Because a document can have many pages, right? 11,000, you can have a document, like a Word document, that is 50 pages, 1,000 pages long. And you call it a document. If it's 1,000 pages, you might call that a book or something. But, right, you could still have a document that has many pages to it. In conversations between Trump's lawyer and the government regarding a data vendor, the government mentioned that the 11,000 documents, contain closer to 200,000 pages. Oh, my goodness. I couldn't even highlight that. I was so excited. Closer to 200,000 pages. So 11,000 documents, we've been told, is actually a whole lot more than that. And that makes sense, right? They came out of there with a whole bunch of boxes. 200,000 pages of documents. That estimated volume, with a need to operate under the accelerated time frame supported by the government, is the reason why so many of the government's selected vendors have declined the potential engagement, right? It's not about they don't want to work with Trump. It's that they don't have the capability or something, it sounds like, to do all of this in the compressed time frame that is needed. In short, Trump's defense says, Judge, seasoned IT professionals who routinely work on large-scale document productions with the government cannot meet the government's proposed schedule. They can't do it. And it was never realistic for the government to suggest such a narrow time frame. And so consequently, they say, Trump respectfully requests, Judge, Your Honor, Raymond Dearie, that the parties will be best served by having retained a vendor to convey a supportable time frame of scanning roughly 200,000 pages into a platform, and also provide a breakdown and a rollout of quantities and proposed deadlines. It would be better to base the deadlines on actual data and not wistful claims by the government, they say. The government also uses this opportunity now of asking for an extension of the deadlines to lecture Trump's lawyers with conclusory and antagonistic comments regarding Trump's filed objections to the case management plan. Trump's defense says, these prosecutors continue to mistake itself as having judicial authority. They and its comments are not argument, but they are proclamations designed to steamroll judicial oversight and Trump's constitutional rights. Along those lines, they say, by participating in this litigation, the plaintiff Trump has not waived and cannot be deemed to have waived any of his rights under the federal rules, including under the Constitution, right? Yeah, and they're saying, look, Trump is entitled to due process. He's entitled to file and litigate these claims. But they're saying that they're making, Trump's defense is making the argument that the government is saying Trump is, usurping the process. And we've covered this at length. They've in their arguments been very conclusory. They've been saying Trump, a judge, Trump has no standing. Trump has no even basis because he doesn't even own the property. And Trump says, we're litigating that, dummies. You can't just come to that conclusion that's never been litigated anywhere. And Trump's defense is reiterating that argument. They continue. They say the prosecutor's lawyers, the government counsel, and their commentary regarding their compliance and our responsibilities misses the mark. Remember, in the previous letter that came over from the government, they were sort of making suggestions to Trump's team. They said, we suggest that you brief this, and we suggest that you brief that. And they're saying, yeah, okay, we know what we're doing. Why don't you mind your own business? A filter team, writes Trump's defense, also known as a taint team, owes its very existence to the notion that using non-case agents and non-case attorneys is the best way to shield the agents and the attorneys from disqualification based on accidental exposure to the privileged documents. If somebody sees a document they're not supposed to see, they get removed from the case. And of course, the government only has so many people and they don't want that to happen. Judge Cannon has already noted, quote, that the privileged team report references at least 2 instances in which members of the team were exposed to materials that was then delivered to the privileged team. This is the point where Judge Cannon, in her original order appointing the special master, remember, the government was saying, Judge, you can trust us. We don't need anybody looking over our shoulder. We don't need a referee to manage this process. We know what we're doing. The DOJ says, you can trust us. And Judge Cannon said, not really. You guys already have 2 instances where your investigative team were exposed to materials that were delivered to the privilege team. Okay, so in other words, the privilege team did not filter the material appropriately. So the judge is saying, so I don't trust you because even in this very case, there have been 2 instances that have been problematic. Trump's team, of course, is highlighting that. They say on Monday, September 26, lawyers for the privilege team provided Trump's lawyers with another example of a filter failure. The email in question was identified, quote, by the FBI case team and returned to the privilege team, which is characterizing the communication as non-privileged, right? So the FBI investigators, they come across this email. They say this email's fine. It's not privileged. They give it over to the privilege team. Trump says Trump believes the email falls squarely into the category of attorney-client privilege. They said it's not privileged. Trump says, yes, it is. The government also provided the special master and Trump with its 3rd version of the inventory in this case, with 53 new documents, clippings, and folders or photos appearing across 16 of the 33 item numbers. And I thought it was 63 because that's what the Epoch Times came out with when they did their math, but maybe somebody's math is off by a 10. Easy to do. They're saying 53 new documents. So when the FBI went and seized all the documents the first time, they didn't capture everything. They made mistakes and they submitted it again. And they're saying there were additional mistakes is what Trump's team is saying. A prior entry for 2 empty folders with, quote, classified banners has disappeared from item number 33. Where'd that one go? Why did item number 33 originally have this line in it, but now it doesn't? Oh, yeah. Because some dumb FBI agent can't manage evidence is what every single defense attorney is thinking out there right now. Oh, yeah. Oh, yeah, maybe they put it in there. Maybe they took it out. Maybe they're manipulating the evidence. Maybe they pulled them all out of the boxes and threw them all over the ground for their little photo op. The unilaterally imposed filter team, writes Trump's defense, which made no effort at all to contact Trump's lawyers through its review process, has admitted to 3 breaches so far. All this before review by the special master and by Trump. And by way of this filing, they say Trump is asking the special master to order disclosure of the names of each attorney and every special agent who was exposed to materials that were eventually given over to the privilege review team. And finally, James Trusty for Donald Trump says the government chose to include in its public filing references to our objections to the amended case management plan. And they say that was sent directly to Chambers as a letter saying, Judge, we sent you a letter under seal privately. And then these jerk DOJ members at the DOJ, when they responded to this, they referenced our filed material that was filed under seal. In other words, we wanted it to be secret, but they talked about the secret stuff out publicly. And they say, we sent that directly to your chambers, Judge. A copy of our letter is enclosed here. And they say, for consistent treatment and to preserve those objections before your judge, we sent that over. We remain available to discuss all of these things. Otherwise, we're going to continue to review and categorize these documents as soon as we get them in an effort to expeditiously complete this under the federal rules. Signed by James Trusty out there, law firm in Washington, D.C. Lindsay Halligan's also on this list. She's out of Fort Lauderdale. And M. Evan Corcoran. Of course, we know who he is. But do you notice who's not on this? Oh, yeah, Christopher Kesey. No Christopher Kesey on this list. Interesting. All of this being copied over to Jay Bratt, Edelstein, and many others we've already followed, along with the certificate of service. That is Donald Trump and his defense team's objections to Judge Raymond Dearie's special master, his case management plan. And they submitted, in addition to this, the letter that they sent previously. This is the 3-page letter that was filed under seal, sent directly to Judge Raymond Dearie's chambers that was referenced by government prosecutors. They say, Dear Judge Dearie, through the undersigned counsel, Donald Trump provides his position to your plan. To help with finding facts, they say that the appointing order authorized a declaration or an affidavit by a government official regarding the accuracy of the detailed property inventory. This is very important. Remember that Judge Dearie, who is the special master, said that both sides need to declare the accuracy of the property inventory. We want a final list of everything that was actually taken so that we can start working off of that list. If we're going to start fighting over, is this attorney-client privilege? Is this a presidential record or a personal record? Is this classified or declassified? We got to know what the entire list looks like before we start separating them out. And so the special master said, okay, government, they're going to make their list. They've modified it 3 times apparently. And then they're going to send that over to Trump. And they're going to say, Trump, now you have to also claim that this is final, right? Trump says, we object to that. We don't want to do that. They say, here, Judge, you ordered us to provide all of this and to communicate to you whether this signed document represents a full and accurate accounting of the property that was seized from Mar-a-Lago. They say the appointing order contemplated no corresponding declaration or affidavit by Trump because the special master's case management plan exceeds the grant of authority on this issue. They say Trump must object. Additionally, Trump currently has no means of accessing the documents bearing the classification markings, which would be necessary to complete any such certification by September 30th, the currently proposed date of the completion. So Trump was ordered to provide this material, and he does not want to do it. He says the appointing order provides that the special master review all of these materials and that Trump is going to categorize the document into one of these 4 categories. Number 1, personal items that are not privileged, personal documents that are privileged, presidential records that are not privileged, and then presidential records that are privileged, right? They have the final list and then they put them into different buckets. They say because the amended case management plan, right? They're saying, hey, Judge Dearie, you're going outside of the scope of the original order. You're saying, so say here, we've got several different things we have to clarify. I think I kind of skipped over this a little bit quickly. Remember, this is the appointing order. This is not the Raymond Dearie order. So Judge Aileen Cannon issued one order that appointed Special Master Dearie. Special Master Dearie then created a case management plan and made some proposals in the case management plan. In the case management plan, that's where he was saying, Trump, you have to confirm the list is what the list is. Trump's defense is saying, Aileen Cannon did not require us to do that in the original order, right? Saying that the original order had no corresponding requirement in there. Judge Raymond Dearie, you're adding that in. You're adding that additional layer, saying we have to fill this out. Judge Cannon never told us we have to do that. And they're also saying, Judge Raymond Dearie, you're saying you want us to do all of this other stuff, but Judge Cannon only said these categories. And so don't tell us to put them into different buckets if that's the only thing that she said. And she has the original power. Dearie can't go outside of the scope. He can only go, the room is only so big. He can't go outside of that. And he's trying to do that. And so Trump's team says, all right, look, Judge Dearie, they say, look, because the amended case management plan that you just came up with goes beyond the grant of authority in the original appointment of you, the special master, and it suggests an allocation into one of 6 categories, we object, meaning Trump objects. Aileen Cannon said 4 categories. Judge Dearie, you're saying 6? Where'd that come from? That's bigger than what Judge Cannon gave you permission to do. We object. Consistent with the appointment order, they say plaintiff Trump's counsel intends to allocate the documents into the 4 categories identified by the district court. They say as the appointment order also authorizes you to make recommendations regarding executive privilege, we're also going to provide assertions and bases for that privilege as well. But we see no basis for segmenting that privilege as described in your amended plan. So, Judge, we're going to do what the actual judge told us to do. Special Master, we're not listening to you. We're listening to Aileen Cannon. We have paragraph 3, section 3. They say Trump reserves all rights under the law and all the applicable rules and the legal equitable relief that are available for the search and seizure of his home. And by initiating this action, Trump does not waive any of those rights available to any citizen under the law. And just because he is litigating this, it doesn't mean that he's suddenly open and fair game for anything goes. Trump's defense says, as noted in our proposed agenda in advance of our last status conference, we reiterate in our view that Judge Cannon, the original judge, was aware of the likelihood of litigation and established a process by which the special master would evaluate the claims before making recommendations to the court. And they're saying that litigation and reports on that should be provided to the court. The district court's decision to exercise this authority over matters surrounding Mar-a-Lago search warrant was a hotly contested component of the litigation to date, and as was the establishment of a special master. There is no indication in the appointment order that the district court is contemplating a carve-out of related litigation for a merits determination, and they say we respectfully suggest the briefing requirement be withdrawn from your final plan. Meaning we don't even want to talk about that because it's not relevant at all. Saying the court, the lower level court, the district court has already decided this, and so we don't need to brief it. They say, all right, Judge, that's our opinion. Basically, we object to all of your plan. Thank you for the opportunity to address our concerns with your plan, and we look forward to continuing to review these materials. Signed by Donald Trump's defense team, James Trusty. Oh, but look who's here on this one. Christopher Kesey. Now, very interesting. Christopher Kesey signed on this one, and that was on September 25th, but Kesey is not on the September 28th filing on the same header. He was taken off. Very curious. Stuff like that is intentional. I wonder what happened there. And we already talked previously that CNN had sort of had a rumor that there may be some maneuvers happening there. But those were Donald Trump's objections. Okay, so those are the 2 things. They say we object to the special master plan. We also, Trump was filing his objections over to the special master. And that second letter is what the government was referencing when they were talking about this stuff publicly. So saying, that's not appropriate for them to do that. They should have honored Trump's intent, which is to keep this stuff private to the judge. Instead, they didn't, right? They just sort of were airing all of that out publicly because they want everybody to see this, which is pretty inappropriate. Judge Aileen Cannon responds to the prosecutors and to Donald Trump and to Special Master Raymond Dearie and is granting and rejecting different parts of the Special Master plan. This is the order from Judge Aileen Cannon in the Trump Mar-a-Lago search warrant case. You can see she submitted this on September 29th. It's 6 pages long, and this is her order accepting in part and rejecting in part the amended case management plan that came over from Special Master Raymond Dearie. This is the official order, And we've already seen several different interim reports and different filings hit the court docket. And this is Judge Cannon summarizing it all for us. She says, all right, this cause comes before this court. We have already talked about all of the documents that got us here. You can see all of these filings, the plan, Trump's objections. We got the government's rejections or a response to Trump's objections and the whole thing. But the judge is going to break this up into three parts. Cannon writes, in section 1, verification of the detailed property inventory. So we had just gotten done understanding how this works. Raymond Dearie said, go fill out the spreadsheet, government, turn it over to Trump. Trump, you verify it's done, make sure it's all valid, and then we move on. But Judge Cannon is going to rule on that. She says, okay, my order, the original order that appointed the special master, authorized the special master, Dearie, to verify the property that was identified and that it represents the full and accurate extent of the property seized on the premises, including stuff that was seized from the DOJ. Now, she says, the court's order imposed no additional requirements on the parties regarding the detailed property inventory. All right. Saying the special master is authorized to verify that the property represents the actual property that was seized by getting affidavits from the DOJ. See that? The DOJ. The order doesn't say anything else about anybody else in the part, any other parties who were involved. Okay. It doesn't say also from Trump, also from anybody else. It says DOJ personnel. That's it. Following the court's order, the plan directed the defendant on or before 9/26 to supply a declaration or an affidavit as to whether it represents a full and accurate filing from the premises. They say the defendant, this is the government, has since complied with that requirement by filing a notice of the redacted affidavit, right? And saying the judge is going back through her original order and just reminding everybody what she said. And here she continues. She says, in addition to requiring the government, the defendant, to attest to the accuracy of the inventory, the plan also requires Trump on or before 9/30 to lodge objections to the inventory's contents. Government makes a spreadsheet. They promise it's true. Trump objects. Specifically, she says, the plan requires Trump to submit a declaration or an affidavit, including each of the following: a list of any specific items that were not seized, a list of any items that were seized, but were seized in different locations or had different contents. So another thing was going to be stuff that was seized, but is not shown up. Okay. So you have something that might be on the property list that was not actually taken. It's still at Trump's place. You have stuff that was in fact taken from Trump's place, but they say they got it from Melania's closet, and they really didn't. They got it from Barron's room. So different location, or stuff that was seized, like that they actually took, like, they actually took Trump's, or Melania's, whatever. And they say, we're missing the red underwear. Okay. The red ones. We know that's our favorite pair, and that's gone. Where is that one? It's not on your property list. The plan frames this requirement as Trump's final opportunity to raise any factual dispute about the accuracy of the inventory. Aileen Cannon says Trump objects to this inventory, this pre-review inventory, citing the court's order appointing a special master. They're saying, hey, we can't even see the documents, the current inability to access the seized materials. So how can we possibly, Judge, confirm for you whether there is in fact good materials, good data, that we know what's actually going on, because we haven't even seen what's in the documents. We don't even know. Judge Cannon writes, the government, for its part, moves to adopt the plan's requirements, right? They want Trump to have to comply with those obligations, saying it's necessary to commence the review process. In other words, Trump has to confirm that it is what they say it is before they can continue their job. Judge Cannon continues. She says, upon review of the matter, this is what I've decided. I've listened to the prosecution. I've listened to the government. I've listened to the DOJ, the FBI, everybody who's involved in this case. I've listened to Donald Trump and the defense attorneys, and I've listened to you, Special Master Raymond Dearie. And here is what the court determines. There shall be no separate requirement on Trump at this stage, prior to the review of any of the seized materials, to lodge ex ante final objections to the accuracy of the defendant's inventory, its descriptions, or its contents. There is no requirement that Trump actually confirm and corroborate that property inventory list. Special Master Raymond Dearie said you have to do that. Many people on Twitter, people like Andrew Weissman, said you have to do that. This is crazy. How can you not confirm that the list is accurate or not? And Judge Cannon just came back out and said, no, sorry, there shall be no separate requirement on Trump at this stage, prior to his review, even looking at the documents, to make him verify and confirm that it is true. The court's appointment order did not contemplate that obligation. Judge Cannon saying, I didn't write that down. They say Trump, the government says, Cannon says the government since has complied with the requirement to update its inventory, and the parties and the special master are now situated to proceed forward with the review process pending the exchange of the actual materials. Should any additional matters surface during this review process that requires consideration or reconsideration of the inventory or the need to object, the parties shall make those matters known to the special master for the appropriate resolution and the recommendation to this court. Paragraph 2. Review of the seized materials. This is a big win before we move on. That's a pretty big win for Donald Trump. No separate requirement that Trump has to confirm and corroborate the accuracy of the government's inventory. That's a big win. Section 2. Review of the seized materials. Cannon writes, the following deadlines and the procedures are now going to govern the parties' reviews of the seized materials. No later than October 5th, the parties shall agree upon and finalize a contract with a document review vendor who's going to host the materials in electronic form. And no later than October 13th, they say government shall make available to Trump and the special master copies of all seized materials, except the materials already identified by the privilege team as subject to attorney-client privilege. Saying all those materials have to be delivered over in electronic format with each page bearing a unique Bates number. Saying that the defendant also shall provide an electronic spreadsheet, meaning the government, shall give Trump an electronic spreadsheet that correlates the Bates number with each document and the item number, right? In other words, so the Bates numbers are a numbering system for complicated, it's sort of like, what was the Dewey Decimal System type of a thing when your library, it's a sort of a filing organization numbering system. And they're saying that has to match the numbering system once it's put into evidence, has to match the actual property inventory so that Trump's defense can corroborate the two. Cannon continues. She says, the privilege review team has provided to Trump's lawyers and the special master documents already designated as potentially privileged, and so we don't have to worry about those. Now, no later than October 14th, they say the government shall file a notice of completion on this docket, certifying that it has been made available to the plaintiff all of the seized materials as set forth above. So we're going to see a lot of activity in October, some pretty good deadlines. No later than 21 calendar days after the receipt of defendant's notice of completion, they say that Trump shall provide copies, a special master, with one comprehensive annotated copy of a spreadsheet that details the specifics for each document and whether Trump asserts any of the following. So the big spreadsheet is going to be delivered over to Trump. Trump then gets 3 weeks to go through the spreadsheet and provide one big Excel file right back. And each Excel entry, every single row in there, is going to have this document falls into one of these categories, either attorney-client privilege communication, attorney-client work product privilege, executive privilege, presidential record within the meaning of the Presidential Records Act, or personal records within the meaning of the Presidential Records Act. 5 categories will now be something that Trump categorizes these each row into. And Cannon says Trump's designation shall be on a document by document basis. So every single one, right? Document by document. Paragraph 3 Says, for reference and for context, it took the government's team 3 weeks to complete its review. And so, Trump, you're also getting 3 weeks. For any document that Trump designates as privileged or personal, they say Trump shall include a statement adequately explaining the precise basis for the designation. So if he says, yes, it's work product privilege, attorney-client work product, why? Well, this is a motion that my lawyers and I were working on. It's our actual strategy work product. Okay. Including, as relevant, any possible assertions of executive privilege, a sufficient description of the rationale and the scope of the assertion from which to evaluate the merits of the assertion. The judge wants some actionable data. What can I do with all of this, is what the judge is saying. Cannon continues. She says, following Trump's service of designations to the defendant, the parties are then to confer and attempt to resolve any disputes. If there is, saying after the conferral, no later than 10 days, the parties shall submit to the special master a log of the documents to which the parties disagree. Right? If you say this is a work product, so Trump says attorney work client work product privilege. This is communication privilege. This is Presidential Record, Personal Record Act. Anything like that. The disputes shall be logged. The special master then will go through the disputes and help resolve them. Special master will say, I make a recommendation on this. That is attorney work product, or that is not. Additionally, Cannon says the plan directed Trump to prioritize the filter materials and to provide the defendant with a log of the materials by 9/26. Absent any info to the contrary, it looks like that's done. Parties are required to submit a log back over on that by 10/3. Cannon says, the plan also recommended that Trump review and assert privilege and it be completed on a rolling basis. And to avoid confusion and to enhance organization and clear deadlines, and in light of the order following the partial stay, which came down from the 11th Circuit, removing previous prioritization requirements, they say the court determines that the submission by Trump to the prosecutors of one final log is better suited to manage the process and resolve any disputes. That's interesting. So Judge Cannon is stepping in here and telling them how to do this. It's more than just saying, I defer to you prosecutors and I defer to you special master, and I'll let you guys go figure this out. Saying, actually, this is how I want you to do it. I'm going to put a big spreadsheet order here and you're going to all just work off one master spreadsheet. Cannon says, finally, in light of delays in securing an appropriate vendor to scan and make available these materials and recognizing the more precise quantification of the implicated pages of materials, describing the 11,000 documents approximating 200 pages of materials, right? 11,000 documents, aka 200,000 pages. The court hereby extends the end date for the completion of the special master review from the prior date of November 30th. She's giving them another 2 weeks to December 16th. Oh man, they are not going to be happy about that, because they are saying that this, they want all of this stuff done before the midterm elections. This modest enlargement is necessary to permit adequate time for the special master's review and recommendations given the circumstances that have evolved since. Saying again, should a need arise to make limited modifications to this plan, the court will make those adjustments as necessary. Now, as to the motion for a return of the property, they say once the court has reviewed the special master's recommendations and ruled on any objections thereto, the special master will, if necessary, consider Trump's motion for a return of the property later. And so she's sort of kicking that down the road after the recommendations have been made. Saying the defendant shall submit a responsive brief later, also talking about these staffing concerns. Saying, yep, okay, neither party objected to the proposed fees, and so all of that is now approved. Done and ordered in chambers down in Florida. Hopefully Judge Cannon and her staff there in Florida are weathering the storm okay, because as we know, Hurricane Ian just blew through there. So pretty big win for Donald Trump, if we're being honest about this. Special Master Dearie and the government prosecutors wanted Donald Trump to have to confirm and corroborate the government's property list. And Special Master Raymond Dearie wanted that done. But as we can see, Judge Aileen Cannon ordering there shall be no separate requirement on Trump at this stage. Pretty amazing. So big victory for Donald Trump, and we're going to continue to cover that saga as the Trump case continues, but a pretty big victory. Many more deadlines coming up in October, and of course, we will continue to cover this. Thank you for subscribing. Thank you for supporting the work that we're doing here, and thank you for joining us on the Trump Mar-a-Lago saga.